what is the ruling on a gifted house without full transfer of ownership? How should it be distributed after the parent's death? So matters of ownership are very, very critical in Islam. Right? The early Muslims would say, as the Mashaykh relate, that be brethren, but transact as though strangers. Be brethren, but transact as though strangers. So we should, and one of the aspects is that matters of ownership should be very clear. Matters of ownership, particularly if people own things of value, of consequence, um, one should be very clear about everything ownership related. That's number one. Then after that, um, we should make our dealings very clear in general so that disputes do not arise. So if something was gifted, right, ultimately you need to take these sensitive matters, because this is a matter of, with a house of thousands uh, uh, of dollars. So if the gift was made complete before the final sickness of the father, then the one it was gifted to owns it. However, a gift is owned if possession is taken. If possession is taken. So, for example, if I say, I gift you my cap, but I'm still wearing it, you say, I accept, but you haven't taken possession. It's still on my head. The gifting is not complete. Once I give it to you, then it's complete. So a gift is completed once possession is taken. The legal transfer of ownership applies in the secular court of law. Right? In important matters, even gifts should be written down. You're giving the car, etc., because otherwise disputes arise. So let's say some uncle gave his daughter, named Jumada, the car, said, this car is yours. But then Jumada goes and does some funny things. So the Uncle G says, give me the car back. She says, it's mine. And then dispute arises, because he said, no, I just gave it to you to use. I didn't say it belongs to you. So these things lead to disputes. So a gift is owned upon transfer of ownership. Number one. If the gift was made, so this house is for you, but possession was not taken, then the gifting was not complete. Also, the gift needs to be made before the final sickness, what is called maradul maut, because in order to preserve the rights of inheritors, there are severe limits to transactions made by the dying person in their final sickness. Right? And nothing can be gifted, no gifts to inheritors or others are acknowledged in the final sickness. So that's also a consideration. When was the gift made? If the inheritors acknowledge the gift having been made, then it would be considered to be of the one the house was gifted to, and not from the estate. If they willingly, without pressure, without coercion, anything, accept, then, so if the inheritors acknowledge the gift, then it would be considered for the one gifted and not from the estate. However, it's come from the Salaf, from the early Muslims, that كل مال أخذ بسيف الحياء فهو حرام. That all money, all wealth taken with the sword of shyness is not permissible. Okay? Otherwise, if the gift was not complete, or if the gift was made during the final sickness, and the inheritors don't acknowledge the gift, then that house would be from the estate and would be divided accordingly. And in that case, we have to uphold an important principle, which is that you cannot harbor any ill will towards someone who is exercising their outward Islamic rights. Right? You don't have sufficient proof that the house belongs to you. It's just your word. Then, and you cannot provide witnesses, documentation, proof, then they say, no, we don't accept this claim. You cannot harbor ill will. And the wisdom of that is obvious. Maintaining relations is more important than, a little bit of fleeting worldly wealth. Wallahu subhanahu wa ta'ala alam wa hasbuna wa ni'mal wakil.
لا إله إلا الله محمد رسول الله